Good morning. We're here in the matter of State v. Debrok, and if I'm saying that wrong, I hope you'll correct me. I know you both know everything I'm about to say, but just for those who might be watching on the stream, we've assigned 20 minutes aside. We routinely exceed that time with our questions. If we are asking questions and your time has expired, there's no need to ask permission to answer and continue. Please just answer the questions. But if your time has expired and there are no questions pending, ask that you wrap up your presentation. And of course, if during the initial presentation we are asking questions that go beyond your time, that does not cut into your rebuttal time. You'll have your full rebuttal time. The way we do things may result in one side having more questions than the other. There's no inference to be drawn from that. It's not a reflection of how we see the case. It's just where we have our questions. So with that, ask you to please put your appearances on the record.
Natalie Skabeen for Mr. Debrok.
Thank you.
Erin Middleton for the state.
Thank you. Let's begin.
May it please the court, Natalie Skabeen for Mr. Debrok. Restitution for the entire amount of pecuniary damages that are proximately caused to each victim does not mean that the award must be joint and several. Rather, the broad language of the LRA stating that no defendant is liable to any person seeking recovery for any amount in excess of the proportion of fault attributed to the defendant applies to recovery through restitution or fact patterns or torts that become civil judgments. Because the award becomes a civil judgment, this court and the Court of Appeals have looked to tort recovery to fill any gap in the restitution statutes. This court did that in Ogden, applying proximate causation, and the Court of Appeals noted in Oliver that the preponderance of the evidence standard usually applies to restitution, although it's not specifically mentioned in the statutes. In Utah, allocation by fault is preferred to the point that if requested in tort cases, it is mandatory. And requiring joint and several liability for all criminal restitution does not work considering the breadth of the criminal code. In a case like Laycock, which was a negligent homicide case, with the possibility that the victim who was also driving could have been negligent in the car crash, the state's proposed reading would mean that the defendant pays the entire amount of damage proximately caused, which would include any portion that the victim was responsible for or that was at fault for.
It seems like the reason for many of our cases applying civil damages principles in the restitution context is because the CVRA did used to refer to civil damages, and it doesn't anymore. It imports the word pecuniary, but other than that, it doesn't refer to civil damages anymore. So how is the LRA relevant at all in this situation?
Because the LRA, by the language of the LRA, applies to defendants and to people seeking recovery. So it would apply in the restitution context where it involves people seeking recovery, it involves defendants, it involves finding fault, it involves finding proximate causation. The LRA, by its terms, would apply to the criminal restitution statute, which does have this gap about how to allocate. It doesn't specifically address that in the statute.
Okay, I have a couple questions on that. Before what you last said triggered a question, but I'll just ask that so I don't forget it. How does the language in the CVRA not allocate damages by using the word entire amount? And the language is that the court shall order the defendant to pay the entire amount of damages. And so I could see how if the language instead said something like the victim is entitled to the entire amount of their damages, it may not specifically say how that should be allocated, but it says the court shall order a defendant to pay the entire amount for which that defendant proximately caused. So how is that not allocating it?
Because it's referring to which damages we calculate, what can go into that. So before, when the statute was more specific and said, up to 5 days, or said, what you could recover in a civil suit, And then in 2016, the legislature amended that to say, well, it includes those damages, but it's broader than that. It could also be travel expenses, for example. And now it's been simplified, but it's been simplified on the question of how do we calculate the damages? What goes into that calculus? And it's now very broad. It can be travel expenses. It can be the entire amount of damages that are proximately caused, but that doesn't address the question of, well, what if multiple people are at fault for those damages, and how do we allocate it? And joint and several liability is a form of allocation. It doesn't mean that the defendant is going to pay the entire amount of damages proximately caused. It's just not the preferred way that Utah allocates fault, allocates a judgment which is by fault and proportion of fault.
Doesn't the language, though, saying a court shall order a defendant to pay the entire damages, that seems like an allocation to me, saying you have to pay all of it that you proximately caused.
But it's referring to the amount of damages that are going to become the judgment. It really doesn't speak to how to divide it up if multiple people are at fault or if the victim is at fault. It speaks to the broadening of that calculation, that it can include travel expenses, that it can include lost wages, that there is no longer a cutoff point. That's what that language addresses, and it doesn't speak to allocation.
How do we know that's what that language addresses? What about the statute suggests that that's why the legislature chose to use that broad language?
Well, a few things. One is that it doesn't, if it wanted to address allocation, it could have done so directly. It could have said will be joint and severally liable. Another is that the LRA by its terms seems to apply in this context, and it doesn't, the restitution statutes don't disclaim that and say that it doesn't apply. And then it doesn't have any infrastructure in it, the restitution statutes, to explain how joint and several liability will work, whether a defendant with multiple co-defendants or with a victim who's partially at fault has any means to seek contribution. It's silent on the issue of how to allocate, whereas the LRA addresses that issue specifically and explains how Utah prefers to handle allocation of fault.
It seems to me that if you look at the CVRA and the LRA, it's an issue of the specific controlling over the general, that the CVRA would control specifically for criminal restitution. What's your response to that?
I think it would control if it gave us what to do about allocation. If it said, and it must be joint and several liability in every case, then it would be the specific controlling the general. But here we would argue it's actually the LRA that's specific about how to allocate and what to do when multiple people are at fault, whereas the CVRA doesn't seem to address that issue.
And the LRA has never been applied in a criminal case, right?
So it's been applied when the parties agreed that it should be applied. So that was like the Grant case where the court said both parties agree that we should apportion fault here, that the LRA applies, and so I'm agreeing to do that. And the Court of Appeals also took up that agreement.
Okay.
Our alternative argument is that the statute should at least give the court some discretion in determining the best way to allocate in restitution awards within any given case. As other jurisdictions have recognized, apportionment by fault has benefits in that the defendant would know the exact amount that he'll be liable for. It would be a more realistic amount that will probably seem fair to each defendant, and that could encourage prompt payment and discourage avoidance of restitution payments.
If we accept your argument and we have let's say we have two co-defendants and one is unable or unwilling or what for whatever reason does not pay the restitution amount, isn't that a problem that the victim isn't made whole for his or her losses?
Well, the LRA says that fairness weighs in favor of making every person pay what proportion of fault they have for that, for those damages. And so victims are still entitled to seek restitution from a co-defendant who's not paying. They're still entitled to bring civil causes of action if there is someone who has a lot of resources that should be paying. So victims are not without any.
Let's say that they don't.
recourse.
Let's say that the co-defendant dies or is incarcerated for life and has very limited access to funds. Then what is, then the victim just is not, the victim would just simply would not be able to recover from the other co-defendant, even though that co-defendant also proximately caused the entire amount of the victim's losses.
I think that is the way that the LRA comes down on fairness, is that every defendant should not be liable for more than the percentage of fault that they are.
And I agree with you on the LRA. I'm just trying to square that with the CVRA that says that it's, the complete losses that the victim's entitled to compensation, complete restitution.
And so there's compensation is one of the purposes of the act, and rehabilitation, deterrence. And for some of the reasons that we've argued, it's the case that setting the restitution award at the percentage of fault might, in some cases, make the defendant more likely to pay it, might work better in certain circumstances, might serve those interests better.
Can I ask you about the definition of fault in the Liability Reform Act? It talks about fault as an actionable breach of a legal duty. Is that normally the way we think about criminal cases, that a criminal defendant breached a legal duty not to commit the crime? Do we talk about it that way generally?
So restitution is a strange combination of civil and criminal, and once we've reached the restitution phase, I think that is how we think about it. Is what does this person owe as restitution to someone else? And we use those civil concepts all the time to understand how to parse that in restitution.
And I guess maybe another way of looking at it is, are there any textual signals in the LRA that would suggest that when the legislature defined fault as breach of a legal duty, it sort of had in mind that it would encompass criminal restitution, that it was thinking of, well, by using this breach of legal duty, we're going to be able to wrap in criminal restitution?
Well, at the time the LRA was enacted, it would have known that restitution was already tied to civil recovery, and they were tied together up until 2016. So when they started, that's how they envisioned restitution to be, and it makes a lot of sense because crimes are essentially torts, and the LRA now encompasses, or always did, but the court has explained that it encompasses intentional torts. If there are no further questions, we'd ask the court to reverse.
Actually, can I just clarify? So you're saying the textual hook in the LRA is just breach of legal duty?
Breach of legal duty, the way it defines defendant, the way that it explains that each person should be liable for their proportion of faults. All that seems to apply well to restitution.
Okay, thank you.
Thanks.
Mr. Chief Justice, and may it please the court, Erin Middleton, representing the state of Utah. This court should affirm the district courts and hold that restitution orders are not subject to civil allocation of fault principles. Restitution orders are governed by a comprehensive statutory framework in the Crime Victims Restitution Act. That act does not require or even allow courts to carve up restitution orders among co-defendants who both proximately caused the victim's losses. That is particularly true in cases like this, when those co-defendants were working together as part of the same criminal scheme. Holding each defendant jointly and severally liable for the entire amount of the victim's loss is consistent with both the plain language of the Crime Victims Restitution Act and its underlying goal of ensuring that crime victims are fully compensated. Unless the court has any questions first, I would like to address the following 3 points. First, the plain language of the CVRA does not permit apportionment. Second, the LRA does not extend to restitution orders. And third, criminal restitution orders are distinct from civil judgments. The fact that they might ultimately be docketed as civil judgments at the termination of a defendant's sentence does not show the legislature intended to extend civil apportionment principles to them.
I do have one question. Based on Ms. Skabine's argument, I may have misunderstood this, but I think the response to Justice Pierce's question about is there any indication that the legislature intended the LRA to apply was that at the time it was adopted, the restitution still referred to civil tort principles. Is that your understanding as well?
I believe that when the LRA was adopted, the restitution statutes did refer to civil damages. The restitution statutes, when it was adopted, are quite different than what we have now. Under that framework, restitution was also something that was the court could award as a partial restitution order. It could also, excuse me, let me just look really quick so I get the language right. It also, at the time of the original Restitution Act, said the court may order a defendant to pay a full or partial restitution, which is quite different than what we have now, where the language of the statute says the court shall order a defendant to pay the entire amount of the damages that he proximately caused. I think what exists now is the controlling language, to the extent maybe there could have been room for an argument that the court did, or the legislature might have intended some link between those two. It's been severed by the recent amendments to the restitution statutes that not only take away the discretion in restitution judgments that existed at the time the LRA was adopted and that existed even pre-2021, when courts were allowed to order both complete restitution, or they had to determine a complete restitution amount, but then could order court-ordered restitution. That did have some discretionary components and allowed the court to consider things like the defendant's ability to pay, and also there was a catch-all discretionary factor that said that they could consider any other relevant factors. So maybe under that discretionary rubric, there was some room for courts to consider whether or not there was some fairness consideration that might allocate fault, but the legislature has removed that discretion, and it's also removed the links between restitution orders and civil judgments by pecuniary losses are no longer tied to what can be recovered in a civil action.
But it sounds like you would at least agree that at the time the LRA was adopted, the overall, the Utah Code anticipated that it would be applied in restitution cases under that restitution statute that incorporated civil tort principles.
I don't think I would say take it that far. I don't think that we have any indication that that's what the legislature intended. I think to the extent there was room for that argument, the legislature has severed it. But prior, even to the amendments, in the Graves case, the court said the LRA is all about tort law, and the court said it should not be extended to breaches, even though fault is defined as any breach of duty, to breaches of contract or breaches of statutory duty. And I think a criminal act is a breach of a statutory duty. So there's just no indication, either in this court's precedent or in the language of the statute, that the LRA was ever intended to live outside of the realm of civil tort law. And I do not know exactly what the LRA looked like at the time it was adopted, but now within the definition of fault, we have that list of categories of things that might include like negligence, gross negligence, strict liability, products liability, but all of those things are civil in nature. So I just don't see any language that would suggest it is supposed to,
It doesn't apply by its terms. It only applied because the restitution statute incorporated it and the restitution statute no longer incorporates it.
Right, and I don't think I would say the restitution statute incorporated, I wouldn't concede that the restitution statute ever incorporated civil apportionment, but the restitution statute used to include language that said pecuniary losses could include things that could be recovered in a civil suit. And the court had looked at that language before to decide, for example, in the Ogden case, to say, we think maybe the proximate cause standard from civil liability ought to be incorporated into the realm of restitution. But since then, the court, while it decided as a policy matter to adopt the proximate cause standard in here, it also decided to sever that connection by removing that language, tying pecuniary losses for restitution to what can be recovered in a civil action.
How might in the CVRA, the language that a defendant is responsible only for their own the damages they proximately caused, if you have a multi-defendant case, might that make one defendant liable for less than all of the damages to the plaintiff, and what would that look like?
If you had a multiple defendant criminal case, just to
Criminal
make
case,
sure
yeah.
I'm understanding your question. Well, I think the language in the CVRA would make both defendants liable for the entire amount, jointly and severally liable for the entire amount. And so to the extent they both proximately cause those damages, the order of the court would have to be they're both jointly and severally liable for the entire amount.
Could a court find that one defendant proximately caused a certain amount and another defendant proximately caused some different things?
Yes, I think the court does have room to make that finding, and defendants have room to make that argument, to say, I proximately caused damages A and B, but my conduct was not the proximate cause of damages C. And I think we see a little bit of an example of how this might work in the Court of Appeals case, State v. Oliver, where the defendant had allowed some co-defendant and the victim to come to her home to do some drugs in the living room. And then later, the victim went into the bathroom and did a lot more drugs and overdosed and died. And in that case, on appeal, the defendant tried to argue both that she didn't proximately cause the death of the victim because his overdose in the bathroom was a superseding cause that was not foreseeable, and that the damages should be apportioned. The court held in that case that the apportionment argument hadn't been preserved, so it didn't reach it. But it did remand back to the district court for a fact finding about whether or not her conduct was the proximate cause of the victim's death. So I think there is a distinction, and I think the CVRA certainly allows for defendants to argue that they weren't the proximate cause of the pecuniary losses, and if they convince the court that they were not, then they wouldn't be liable for those damages. But once the court finds that they were the proximate cause of damages by the terms of the statute, it shall order them to pay the entire amount of those damages.
I'm just curious about whether, if you have two defendants and they're both joint and severally liable, and one makes all the payments they're supposed to make and the other one doesn't, and one defendant ends up paying much more than the other. So I guess first, as soon as the judgment is completely satisfied, both defendants are off the hook for the judgment, right?
Yes, and I think either defendant, including the one who didn't end up paying, could file a notice of satisfaction of judgment to hold that the judgment was satisfied.
And is there any recourse that that the paying defendant could have against the one who was sort of a deadbeat and didn't make their payments?
It's not clear to me that there is. My understanding is that there was not a suit for contribution at common law, that existed by virtue of the predecessor of what is now the LRA, although that only applies in civil context, so I don't know for sure. But I think even to the extent there is not, what we still have here is we have to look at the language that the legislature has chosen to adopt in the statute, which holds them to the entire amount of the restitution order and doesn't allow for that. So to the extent a policy judgment should be made to allow that kind of action, I think it's up to the legislature to decide that. Where here they've decided that a co-defendant bears the risk that they might have to pay the entire amount of the damages they proximately caused. And I think that is especially true in a case of concerted activity where they're working together to cause the damages. And even at common law, and even in jurisdictions that recognize contribution actions, my understanding is when you have concerted activity, there's not necessarily that right that you can get your co-conspirators, so to speak, to divvy up the damages among themselves. And that makes good sense, because if you're going to engage in criminal activity and concerted activity, you ought to bear the risk that you are going to be on the hook for the whole damages that the concerted activity caused. That not only helps fully compensate the victim, but it also serves deterrent and rehabilitative effects, which are also pieces of what restitution is designed to accomplish.
I just had one more question about the practicalities of how this might work, and it's a little bit afield from the legal question here, but just so I understand the operation. So in the days of making court-ordered restitution and the complete order of restitution. One of them was kind of part of the criminal case where the court took into account other factors like ability to pay, and it was ordered in the criminal case that the defendant had to make this restitution payment. And I think, and I might be recalling incorrectly, that also was sort of part of your probation, that if you had a probationary term, you needed to pay off all of that to satisfy your terms of probation. The complete restitution was then a judgment that could be collected by the victim, but didn't necessarily hang over the defendant's head in terms of like a probationary term that they still needed to complete. And I might be remembering that incorrectly, so please correct me if I've got that wrong. But how does that work now that there's no difference? It's just this entire amount, regardless of a defendant's ability to pay. Is this sort of a probationary term? Would the defendant who doesn't pay have any consequences in the criminal case because they're not making payments? How does that work with respect to the terms in the criminal case?
And unfortunately, I don't know how it used to work. I'm not as familiar with the practicalities of that back then. And I unfortunately also don't know your question about how it works as far as the consequences for their criminal case. What I do know that has changed is that now it doesn't become a civil judgment any longer until the termination of the sentence. So it used to become a civil judgment immediately, is my understanding,
Yeah.
and now it doesn't become a civil judgment until the termination of the sentence.
Okay.
And then the legislature has added some clarifying language about that also didn't used to be in the restitution statute, that even though it ultimately becomes a civil judgment, it says, this is in section 301 of the CVRA, notwithstanding any other provision of law, that the civil judgments that are filed from a restitution order arise out of the criminal case, remain criminal in nature, shall be construed as a continuation of the criminal action from which the judgment arises, and does not divest the defendant of an obligation imposed as part of a criminal action.
Okay. Thank you.
I think also, in addition to the terms of the CVRA, when we compare the CVRA to the LRA, we can see that the LRA doesn't extend to the CVRA because it is so different. The LRA shows the legislature knows how to adopt comprehensive apportionment of fault if it wants to do so. It didn't do so in the CVRA. And not only that, the CVRA is moving farther away from the LRA with this entire amount language and by removing the link to civil damages. But I think the LRA and the CVRA just don't work together. Either they're incompatible with each other. Under the CVRA, a plaintiff or a person seeking recovery, under the LRA, a person seeking recovery can't recover anything if they're 51% at fault. That's inconsistent with the language of the CVRA that requires pecuniary damages or a restitution order in the entire amount of the pecuniary damages. The LRA also permits joinder of multiple parties, including immune parties, or identifying other parties who are at fault so that they can be joined, so that everyone's in front of the court at the same time, so that the fact finder can allocate fault so that equals up to 100%. And in a criminal case, the case is usually the state and the defendant. We don't have room for those multiple parties to appear and have a fact finder who's been through a whole civil proceeding allocate fault between all of them. And so we would risk having a scenario where you might have a judge look at a co-defendant or at a defendant and say, I think maybe here it's only fair that you only have to pay half of these damages, and then maybe the judge in the other case with the accomplice or the co-defendant might say something completely different and leaving less than 100% of the damages allocated, or that co-defendant might get acquitted, and then we have a defendant who only is ordered to pay half. It just functionally wouldn't work like it does in a civil context. I think that application of the LRA principles too, where they allow fault to be apportioned to the plaintiff, leads to the scenario where we'll have criminal defendants trying to apportion fault to the victims by making arguments that, well, some of your losses were your own fault because you failed to lock your car and left it in the driveway in a bad neighborhood, so it was partly your fault that I stole the car. Or you might have victim blaming for victims of assault, that they contributed to their own assault. In the Graves case, they dropped a footnote that said that that kind of blaming would be absurd and nobody would risk raising it to a jury, but in a restitution we're not at a jury, we already have a conviction, so I'm not sure that those same disincentives would apply, and defendants have in fact tried to blame victims or apportion fault to victims in some of these cases. So I think adopting the defendant's argument opens the door that that victim blaming is going to become part of criminal restitution hearings, and we'll have defendants trying to apportion fault to the victims for being the victims of their own crimes. All right. And then I guess the final point, that civil enforcement mechanisms don't indicate that the comparative liability principles apply. I've already covered some of this with that additional language to this into the CDRA, that those remain criminal in nature. Defense counsel referenced that this court in Ogden did look and has looked to civil damages principles in the past for restitution orders, citing the Ogden case. And I just want to note that the underlying rationales have been greatly changed by the legislature, so that the things that this court looked to in Ogden no longer exist in the restitution statute. I think truly restitution orders are their own distinct animal, even though they become civil judgments. They are not subject to the same civil procedures and civil apportionment that would exist if this were in fact a tort case. The holding that the defendant cannot apportion fault by splitting his restitution award with the co-defendant that acted in concert with him is consistent with the language of the CDRA and its express goal of fully compensating victims of crime. This court should affirm.
Thank you. Ms. Skabeen.
Thank you. I'll start with the state's argument that this was concerted activity. I think that might be a question for remand. There could be instances where conspiracy is charged or there's a plea to conspiracy and joint and several liability might still apply. In this case, in Mr. Debrok's case, the plea was not to conspiracy, it was to unauthorized possession of property, and the plea agreement seemed to contemplate splitting restitution with the co-defendant. The state also argued, or there was some discussion of how proximate cause and, for example, the Oliver case would apply when multiple defendants are at fault. And there was some discussion in the Oliver case about how superseding cause completely cuts off liability, and there's some tension between that and apportionment of fault, which would just divide liability. So there might be some instances where actually the victim is more likely to recover under a apportionment of fault analysis than a proximate cause analysis. But
Can I ask you a question about that, though? Under an apportionment, if the defendant did not proximately cause the victim's damages, how would a judge apportion any fault to that defendant?
I think there might be some cases where it's kind of a close call about whether this is a superseding cause or just another person at fault. Okay. And so apportionment in those circumstances might lead to a result that seems more fair, to say like, well, you're at fault a small amount, but when when it has to be one or the other, it might be the fair way to do it might be to think about it as apportionment instead of just superseding cause that completely cuts off liability.
But I assume you agree that the court could attribute no restitution whatsoever to a defendant who did not proximately cause the damages.
Right.
Okay.
And there was some argument from the state about Grant and the possibility that a defendant might blame the victim for the victim's damages. In the Grant case, if the facts had been as the defendant claimed them to be, which the court found that they were not, but if they had been, then that would have been a case where parties show up to a drug deal, and under the defendant's version of facts, he's not entitled to self-defense because he's at a drug deal. The victims are the ones that drive the car away, that pull out guns, that are trying to rob him. So in that circumstance, it makes a lot of sense to apportion fault and to apportion fault to victims. Of course, that's not how the court found the facts to be, but that doesn't mean that there might not be a place for apportioning fault in a circumstance like that. And there's also some discussion of how the LRA works when incorporating other defendants. In this case, the court said, well, I'm going to look at the co-defendant's case and use that in my determination of restitution. Our alternate argument is that courts should have discretion to decide how to apportion faults, and looking at the other cases, at what's happening to other co-defendants would help the court to make a determination like that. If there are no further questions, we'd ask the court to reverse.
Thank you very much. Thank you for the briefing and the arguments in this matter. We'll take it under advisement and issue a written opinion. We need to take a brief recess to reconstitute the court. When we return, we will hear Jenko versus Valdera Land.